Good afternoon to members of the Roundtable that's gathered here this afternoon. Good afternoon to the citizens and people of Trinidad and Tobago. And welcome to this very important media conference hosted by the Roundtable of Civil Society Organizations. I wish now to read a statement on behalf of the Roundtable. My name is David Abdullah, and I'm the convener of the Roundtable, and I wish to read a statement that we agreed on following a meeting of the Roundtable just minutes ago. And then I'm going to invite a number of persons to add their views to a very important issue which goes to the very heart of the democratic process and our institutions of national life, in particular to the institution of Parliament and the abuse of Parliament by the current government. This is a statement of the Roundtable of Civil Society Organizations. The Roundtable came into being in 2012 following the selective and surreptitious proclamation of Section 34 of the Indictable Proceedings Amendment Act. This was in response to the national outrage against what was clearly an executive or cabinet decision, the implication of which was to provide a get-out-of-jail-free card to certain financiers of the ruling party. It was an abuse of office of the worst kind and an attack on the institutions which underpin our democracy. Since that time, the Roundtable has met, if and when necessary, to follow up on the Section 34 issue and to raise our common concerns about other issues of governance, particularly where, in our collective view, there has been a serious abuse of office and/or a flagrant undermining of the principles of good governance. While there have been many issues of concern with respect to the practice of government by the UNC-PP government, we have generally confined our collective activity as the Roundtable to those matters which have national as distinct from sectoral implications. In the past week, such a national issue has arisen. It is a decision by the government to bring a motion of censure of the Leader of the Opposition to the House of Representatives, which motion had embedded in it not only censure, but also the penalty of suspension from the Parliament. This motion was passed given the government's built-in majority in the House. In the respectful view of many highly respected persons in the country, including former members of Parliament, former presiding officers of the Parliament, and commentators on public affairs, the action by the government was not only unprecedented in this and other parliaments, but was an abuse of office, a violation of the principle of natural justice, and procedurally flawed, as the process that requires any such censure should go to the Parliament's Committee of Privileges, and this was ignored. In the circumstances, what we have before us is a major national issue, one that goes to the root of the parliamentary system, which our Constitution establishes as one key component of the democratic process. It is therefore a matter that the Roundtable can and should consider and publicly comment on. The Roundtable was therefore convened today, Wednesday, May 13, 2015. At our meeting, we had the benefit of the advice of former Member of Parliament and Speaker of the House of Representatives, Mr. Nizam Mohammed, and former Member of Parliament and Attorney General, Mr. Ramesh Lawrence Maraj, Senior Counsel. In addition, we considered the publicly expressed views of eminent and respected persons who have had extensive experience in the operating of the Parliament and the public service. It is therefore the considered view of the Roundtable that, 1, the motion of censure and suspension moved against the Leader of the Opposition was unconstitutional, as it not only contravened the supreme law of Trinidad and Tobago, but also contravened the standing orders and procedures of the Commonwealth parliamentary practices from which Trinidad and Tobago draws authority. 2, it is well established that if there is a breach of privilege in the face of Parliament, that is, if a matter arises with a member making a statement while Parliament is in process, that matter can be dealt with without reference to the Committee of Privileges. And we have seen before where speakers of the House, past and present, may have taken action and suspended a member for that sitting or for more than one sitting because the issue arose in the face of the Parliament. However, in this case, what was being brought to the Parliament with respect to the matter of privileges was whether or not the Leader of the Opposition brought authentic documents, in particular authentic emails, to the Parliament. In such a case, this issue should be determined, cannot be determined by the House itself. It first has to be referred to the Committee of Privileges, where the Leader of the Opposition would have been entitled to be represented by counsel. He would have been entitled to give evidence. He would have been entitled to call witnesses, including expert witnesses, if necessary, and also to demonstrate whether or not the contents of the emails were true or not true. These would be the processes of law, the due process of law, which would be required under the Constitution and the common law, and which ought to have been upheld by the Parliament. All of these were nakedly violated and dispensed with by the government. Fourthly, the Leader of the Opposition was denied not only the due process of law, but also the elementary rules of natural justice, which would have allowed him to be heard at the Committee of Privileges. And we should make the point that while it is the Leader of the Opposition who was suspended, what we are saying holds true for all members of Parliament, that this matter is important not because it is the Leader of the Opposition, but because the precedent that has been set by this Parliament would strike at the very root of the parliamentary process, because no member of Parliament would be provided with the protection of the Constitution, the protection of the common law, the protection of the principles of natural justice, the protection of the rules of procedure and privileges of the Parliament. Fifthly, our position as the Roundtable is that the Speaker of the House, who stands or should stand as the guardian of the privileges of members of the House of Representatives, and who is required to be and appear to be both independent and impartial, in this instance demonstrated clear bias by permitting this unconstitutional action to be taken against the Leader of the Opposition, by allowing the motion to be placed on the order paper and eventually carried by way of resolution of the House, which passage by the House of the resolution was automatic and guaranteed, given that the government has a majority of members in the House. In this regard, we also want to refer to the letter written by a former president of the Senate, former presiding officer of the Parliament, on this matter, when he said, quote, "I am of the view that the Speaker was grossly irresponsible and reckless in approving the motion. By his decision to allow the suspension motion with no alteration, Speaker Mark gave the party in government, with its majority, which all governments have, the license to put the opposition members en bloc out of Parliament in violation of Trinidad and Tobago's constitution. There is no Commonwealth precedence for a ruling party suspending the other party or parties, and Mark will likely get his name emblazoned in the annals of parliamentary journals to our eternal shame." End of quote from the letter written by former President of the Senate, Michael J. Williams. Returning to our statement, 6, the government abused the parliament by seeking to have the parliament determine matters which are being investigated by the Trinidad and Tobago Police Service and the Integrity Commission. And by so doing, the government undermined and subverted those investigations which are ongoing and which the country, of course, awaits the conclusion as a matter of urgency. They also predetermined the investigations by taking the action that they did of bringing this motion of censure, and therefore they used their own investigations to try to establish their innocence, and in so doing, by so doing before the parliament, abused the parliament in the worst possible way, because the parliament is not the place where one ought to try to hear and determine a matter which you are the subject of investigation. 7, the Roundtable now calls upon the government to remedy this most serious and egregious breach of the parliamentary process, of the Constitution, of the rule of law of Trinidad and Tobago by going back to the parliament and using their majority, removing the suspension immediately of the leader of the opposition. And that is our statement which we wish to make to the people of Trinidad and Tobago